This article contains material that may be disturbing to some readers. Former Nine Network reporter Ben McCormack was sentenced to a 3-year good behavior bond today after pleading guilty to 2 counts of transmitting, publishing or promoting child pornography. McCormack, under the username Ounce4Skaboy, had chatted for some months via Skype with a Perth primary school teacher about their mutual sexual attraction to boys as young as 3. McCormack described himself in the messages as a proud boy, lover. In another, McCormack says of underage boys. Outside court following a hearing earlier this year, McCormack's lawyer insisted that the exchanges were nothing more than fantasy talk. In considering the objective seriousness of McCormack's offending, District Court Judge Paul Conlon specifically noted that the conversations were purely fantasy, and harmed no actual child victim, as reducing the overall severity of the offence. But does fantasy talk stack up as an excuse under Australian law? What the law says: Australia has a comparatively broad range of child abuse criminal offences. The Commonwealth Criminal Code provides for a number of telecommunications offences relating to the use of a carriage service, the Act's term for Internet technologies, to involve children in sexual activity. Conduct prohibited includes the possession and distribution of child pornography, grooming or procuring a child for sexual activity, and acts of indecency toward children. The maximum penalties for these offences range from 7 to 15 years imprisonment. These provisions complement offences in each state and territory of more traditional sexual offending against children. However, it is only in cases of online offending that the law must confront the prospect of sexually explicit child abuse fantasies. Pure fantasy as a defence. There are some online child sex abuse offences in Australia for which a defendant's claim that they were purely fantasizing could excuse criminal liability. More serious online offences, such as grooming or procuring a child for sexual purposes, require proof that the defendant held a specific intention. These intentions are often inconsistent with pure fantasy conversations. For example, the procuring offence requires proof that the offender intended, at the time of the relevant conversations, to encourage, entice or recruit a child for sexual activity. The inquiry as to the offender's intention is subjective. However, the intention doesn't need to be specifically determined for a defendant to be convicted. A general intent to engage in some form of sexual behavior with the recipient is sufficient. The Victorian Court of Appeal has said the provision requires no proof of fixed intention at all. However, it would be wrong to think of this requirement as imposing no burden on the prosecution. Some engage in sexually explicit online conversations for the purpose of their own sexual gratification, and with no intention to act on them. These individuals could hardly be said to intend to encourage, entice or recruit a child for sexual activity. Discerning the offender's true intention often requires a detailed review of the contents of online conversations.